Well done.
Thank you, Madam Speaker. I rise to lead for the opposition on the Retail Leases Amendment Review Bill of 2016, and Madam Speaker, at the outset I wish to highlight the opposition's concerns at the lack of consideration by the government for key stakeholders on this legislation. After 3 years of consultation, negotiation and debate on this bill, they were ambushed on the 8th of November when the Minister came into this place and dumped the legislation before us. Many of them were preparing for the busiest 6 weeks of the trading year, and they suddenly had to prepare briefings on a bill that frankly many never thought would see the light of day. Then after Christmas came sales and back to school, and finally Valentine's Day yesterday. The Deputy Premier has apologised for the late notice of his introduction of the bill. However, I find it hard to accept his commitments that this won't happen again, as it appears that this newest incarnation of the Liberal National Government of New South Wales is still not quite showing retailers and shopping centres the love they deserve by again commencing debate on this legislation with just 1 day's notice. Indeed, as late as last night, I had stakeholders contacting me with new concerns that they had only just had time to fully consider the legislation, which has more than 50 amendments to the Act. The Deputy Premier needs to learn that his actions must speak louder than his words, and while he might speak of supporting small businesses, he actually has to walk the talk. Speaker, I also wish to advise the House that, like my colleague, the Deputy Premier and Minister for Small Business, I have been and I continue to act in various capacities as both lessor and lessee of various retail businesses. We perhaps have a lived experience in this area, which is good for the business community of this state, and further, both Labor and the Nationals leader have made a commitment to act in a bipartisan manner on this particular piece of legislation, given the extraordinary length of time it's taken the government to get to this place. Bipartisanship doesn't mean, however, that I won't raise the issues on the many stakeholders who I've consulted with on this bill. As a member of the opposition, I'll continue to advocate for better legislation that affects all members of our community, particularly in my role as Shadow Minister for Small Business, the business community. With the length of time this legislation has taken to get here, we could have expected great legislation with great protections for small businesses and retailers, and something which balanced the risk properly between all parties in the relationship, because small business in this state deserves much better. In fact, contrary to the mythology promulgated around this place by members on the other side of the House, it's the Labor Party who has really understood the needs of small business in this state. And Labor who have fought to have a level playing field for mum and dad small businesses to ensure they are not cannibalised by large multinational corporations.
How many small business operators on that side?
Though the Minister applauded his predecessor, the Honourable Ray Chappell, in fact it was the late Honourable Brian Vaughan, as Shadow Minister for Small Business, Industrial Development and Tourism and Deputy Leader for the Opposition Legislative Council, who was instrumental in forcing the then Fay government into introducing the Retail Leases Act in 1994 to protect small businesses from unconscionable conduct and misleading and deceptive conduct by landlords. Without Brian Vaughan's tenacity to change the leasing culture and provide some protection for retail tenants, the Act would not have come into being in the first place. That legislation became the model legislation for other states and significantly changed practices in the leasing market, which had previously displayed cavalier attitudes to tenants with no respect for their contribution to the economic wealth of shopping centres, while they made claims about rent which were often never substantiated. The legislation changed the culture significantly, addressing the imbalance of sales and rental knowledge between tenants and their landlords. I remember many years ago in one of my first jobs working for a small family jeweller, seeing the inequity of how they were treated. They were a unique and wonderful boutique jeweller who had been operating for many, many years, which generations of families had gone to purchase wedding and engagement rings from all over the city. However, they paid far more per square metre of floor space than the large national retail department stores, because they were not seen as an anchor tenant in the shopping centre. In other words, they apparently didn't attract customers to the centre. And the travesty of this kind of bean-counting thinking was proved so wrong when indeed just last year, during a redevelopment of the centre this particular business was operating in, they were offered a wholly unsuitable space, so they decided to close down their store. Over the next 3 months, they had queues out the door of the shop of customers from all over Australia who wanted just one last purchase of the beautiful jewellery they had for sale. It's often these small boutique retailers and small businesses who are the main attraction for shoppers, who are sometimes critical of the generic nature of modern shopping centres, of being just one small retail family business. Even after having operated for 3 generations, this business just did not have the bargaining power to change the terms of their lease or ensure they were given appropriate space during renovations, an issue that's been raised with me by many of our stakeholders. So in 2017, some 23 years later, after the release of the first legislation, what has changed in the relationship between retailers and shopping centre owners? Is it still a battle of Goliath and David? And do we still know who Goliath and David are? The advent of the internet and its capacity to change the way we live, work and shop has been a fundamental disruptor to the retail industry. Retail small businesses, as the ultimate entrepreneurs in our economy, have dealt with it the way they always do. They work harder, they diversify, they improve their relationships with clients, and they just make more with less. And shopping centres, the landlords, have similarly had to grapple with the disruption of technology and also with the demands of a much more sophisticated consumer with greater ability to travel further in order to shop. They've also suffered the challenges of retailers who are multinational brands, which wield far more power in the relationship than the landlord. Sometimes Goliath can become David in this scenario. Since I took over this portfolio just 11 months ago, I've travelled around the state visiting some 15 regional communities, from Albury in the south to Tweed in the north, from Broken Hill in the west to Orange and Port Macquarie. I've seen firsthand the issues for regional and even outro-metro communities in activating retail centres in the traditional high street shopping strips. The combination of absentee landlords who don't care if their shops are empty and councils struggling to attract the right mix of retailers, cafes and professionals to activate commercial spaces in their communities have meant that many of our regions, towns and cities have large CBDs which are only half full. In fact, when I was in Monero in the Minister's own election, it's an issue that he acknowledged they struggle with down in Queanbeyan with a lot of empty shops. Sometimes government policy changes such as the truncation of the rail and the Hunter can have negative consequences for retail precincts, with little power for them to ensure the safety of their shopkeepers, their staff and their customers. And this is an issue that's been really pushed home to me by some of my local retailers. Yet in many of these towns and communities, the retail shopping centres are buzzing. They offer a variety of value adds which attract shoppers. The floor's level, it's easier for trolleys and prams, doors are wide, there's escalators and elevators, there's plenty of parking, there's very few empty shops, entertainment and dining options are generally available on site, and the facilities and amenities are usually accessible and clean. Shopping centres manage the activation of their spaces and they create retail communities and economies which are often almost quarantined from poor decisions by government. They too, as I've said before, are sometimes at the mercy of large national, multinational retailers who have more power than them. Retailers too are far more sophisticated than ever before and are grappling with change. They generally have online shops as a standalone and sometimes integrated part of their retail offering. They work hard on their visual presentation, they've developed loyalty programs, excellent training for their staff, and the hard work of shop assistants provides that personal and responsive service which just can't be matched online. Even big retailers do it tough in a disrupted industry, as large national retailers which have been household names for many years, like Dick Smith's, Payless Shoes recently and other retailers, have gone into administration and or liquidation. It's often the small retailers who are making those necessary changes to provide an unique selling proposition to their customers in order to survive. And that's why, with all this change going on in the sector, it's a shame that it's taken the government so long to get here. The Retail Leases Act 1994 was aimed, as I said before, at greatly improving the leasing culture and expanding and ensuring the rights of tenants in New South Wales. In large part, the Act has been successful. Over the last 23 years, the needs of lessees and lessors in retail tenancy agreements have developed, and the legislation must be amended to address these needs. The statutory review of the Act commenced in 2013 with a series of meetings held with various stakeholders. The discussion paper identified 8 key areas of concern, and in October 2015, the Office of the Small Business Commissioner proceeded with the review, which had lapsed due to the March 2015 election. Some stakeholders have expressed to me the view that the appointment of the Office of Small Business Commissioner to head the review, and I acknowledge in the gallery there, Robin Hoggs, was not indicative of a true desire by government to have a totally impartial view, as the office tends to do the mediation on many complaints. They have indicated that they felt it would be like getting a prosecutor rather than a judge to oversee a court case. Of course, I know that the Commissioner would have done everything she could to address these concerns. But most importantly, as I alluded to before, it's of grave concern that it's taken this government 3 ministers to get to this point. And in fact, even the Deputy Premier has taken 14 months to get us here, even after all the work of his predecessors, and I acknowledge the member for Cootamundra, the former Minister and Shadow Minister. I'm sure, like me, stakeholders were unsure during the instability of the various reshuffles the government's been engaging in over recent months whether or not we'd have to start again with yet another coalition minister. Indeed, I'd like to pay my thanks to the many stakeholders who have engaged with me on this issue, often late into the night when we weren't sure if the legislation was going to be debated the next day. I'd like to particularly thank the following stakeholders for their comprehensive responses to my questions, including Michael Loney from the National Retail Association, Russell Zimmerman and Heath Michael from the Australian Retailers Association, Angus Nardi and Kristen Price from the Shopping Centres Council of Australia, Mark Douglas from the Pharmacy Guild of Australia, Luke Aitken from the New South Wales Business Chamber, Damien Paul from the Franchise Council of Australia, Gabriel Lee and Liza Booth from the Law Society of Australia, Catherine Horgar's partner in Mills Oakley Lawyers on behalf of the Australian Institute of Conveyancers, and Merrin Willits, the former Small Business Advisor to the Minister, and the current advisors, Kaylee and Rachel over there. Again, I thank them and all the stakeholders for their tenacity in sticking to a process over such a long period of time. The bill generally represents those matters on which consensus was reached. And of course, in my negotiations, I've had many stakeholders seeking to raise issues with me where consensus was not reached, and I am very aware of the impact on that. But as I said, they have, having worked on this issue for over 3 years, they have been united in saying that they were losing faith in the government to be able to manage to bring the legislation to the table, and their concerns that if they didn't get it here, if it doesn't get passed, that it will never be passed. And we take that very much into consideration in our consideration of this legislation. Stakeholders have also noted changes to retail trading hours introduced by the government and other legislation which has actually been ongoing while this bill's been negotiated and had impacts on it. Indeed, we saw the introduction of a trial of Boxing Day trading at the same time as this bill was under statutory review, indicating that perhaps even the Premier herself as Treasurer was unsure if this legislation would ever come before us. But now at least it has. So I turn to the legislation. It's been proposed that landlords would be required to publish effective rents and turnover at a centre level against an agreed criterion. If the landlord fails to publish the data, the clauses in leases relating to turnover would be avoided. And this is something that has been very important for all parties in relation to information asymmetry and transparency. But when it comes to reporting and calculation of turnover revenue figures and determination of rents, there are always concerns, and this is to be expected in any commercial relationship. Reporting of turnover figures by tenants to the landlords is one of the major factors in determination of rent. Other factors include the status of the lessee, as I alluded to before, as an anchor or ancillary lessee, and anchors tenants are those who are identified as tenants who bring in customers to a centre. Traditionally, as I said, these are mainly large retail chains, for example, stores like Apple, JB Hi-Fi, David Jones, Myers, etc. And as I said before, small boutique quality and niche shops tend to pay more per square metre of rent, even though they're often the ones who bring in high revenue customers. Generally, the higher the turnover, the higher the rent. In the old days, tenants were able to basically report their own nominated turnover to the lessor. However, in recent times, with the implementation of GST legislation and the movement to more computerised systems, landlords are able to collect the data electronically, and there is less potential for fudging the figures to try and obtain a lower rent. In fact, I note that I worked for one small retailer who used to have his books for the tax office and his books for the shopping centre, and probably there was another set of books which was actually what he turned over. The legislation provides for greater sharing of data in terms of rents and turnover, which provides an opportunity for tenants to benchmark in their business performance and compare rents with like tenants. And of course, this is actually seeing a proactive reason for collecting this data, and so of course that's a good option. The data is reported confidentiality, although many alluded to the issues where there's only one or two tenants in a particular category. Of more contention, of course, has been online transactions. So Section 20 is amended to prevent revenue from online transactions from being included in turnover for the purposes of the determination of rent on the basis of turnover, except for transactions where goods or services are delivered or provided from or at the retail shopping centre, or where the transaction takes place while the customer is in the retail shop. A new Section 47 prevents the lessee from being required to provide the lessor with information about online transactions, except for transactions where goods or services are delivered or provided from or at the retail shop or retail shopping centre, or where the transaction takes place while the customer is at the retail shop. It gets quite complicated in our new modern world. Around 20% of tenants under this Act are located in shopping centres, and with changes to technology and commercial transactions, many are becoming less focused on bricks and mortar shop fronts and more on their online shop front. This has major implications for turnover reporting and management. The legislation covers the click and collect transactions where the lessee is essentially using their retail premises to facilitate the transaction. However, the legislation does not provide for landlords to collect rent based on turnover that is generated completely online, for example, home delivery or online services, which is fair. There's risk for the landlords that tenants could potentially be able to report less of their online figures, giving rise to fudging again, as the money gets paid via an online portal which may or may not be covered by the in-store registers that report directly to landlords. This could be, for example, by classifying all sales as online sales where there may be a high proportion of click and collect transactions. It's interesting as a consumer to see what the many stores are basically moving to have a showroom format where only samples of goods are displayed in store, and sales consultants actively encourage customers to order online and then receive the goods by mail. And as I said, it can be unclear how these transactions would be reported if the retailer wasn't completely upfront with that. I was advised by the Minister and his advisors that shopping centres wanted to include all online sales in the transactions. However, when I spoke to the Shopping Centre Council of Australia, they told me that they merely wanted the section removed from their legislation as they believed it would not cover some of the opportunities for both retailers and shopping centres to increase sales turnover to their mutual benefit if they only had the capacity to change the legislation every 3 or 5 or 10 years as technology continued to fundamentally change commerce. In fact, they told me about some of the very innovative work on online transactions, including in some centres setting up concierge services where customers can go to the shopping centre to collect goods from shops which they could not do during business hours. For example, if I wanted to purchase a pair of jeans online through my local retailer, I might not be able to get there between 9 AM and 5 PM to pick them up, so I could go to the concierge desk and collect them, or even try them on while I'm there and check that they're a good fit. I even thought about this myself and how, if we want to buy from Australian retailers, we should be working with retailers and the shopping centres to capture more business here. For example, nearly 5 years ago, I travelled to the US on a holiday and bought some jeans. Now I love those jeans, but they're starting to wear out, and I can't get the same style here in Australia. Apparently myself and the buyers for the shopping centre disagree on what sort of brands of jeans Australian women like. I can get the brand in Australia, the same brand here in Australia, but I can't get that same specific style. Now, Australia Post is dealing with this by providing online post boxes to Australian customers to purchase products from America directly. However, wouldn't it be better if I could go down to my local retailer of jeans who stocks that brand, order it online in store and then get it delivered to them so I could actually have an Australian transaction? No putting my credit card details online. I can try them on to make sure the new pair still fits correctly, and best of all, the local retailer who provides the local jobs gets the sale. And I acknowledge the interjection there of the member for Cootamundra who says that is available in some stores, and it would be good if it's rolled out. There are so many ways we could be working with retailers and shopping centres to improve sales locally and provide local jobs. It seems a pity the government wants to put all this in legislation rather than allowing it to be in the code where the retailers and the centres, who are obviously more on the ball in terms of what's happening, have more control over how they operate as the technology changes. It could also be argued that if the code is to be used to determine turnover, then more flexibility should be allowed, and that agreements about the inclusion of online data should be included in that code. The Minister's been given some proposed amendments which make the carve-out intended by the government considerably clearer, while respecting the government's intent to set parameters around the consideration of online transactions. However, when I spoke to the Minister and his advisors on this issue, Mr Speaker, they appeared to be unaware that the online turnover was included in the legislation, and so they were unsure if they could accept either the proposed amendments to the legislation or its removal from the bill. I must say I was very disappointed that such an important issue, which has been negotiated for so long, appears to have been given such scant regard. The issue of online turnover is one which will definitely need to be reviewed as more technology-based retail starts to occur. The sector is in huge disruption, so this issue is anticipated by all stakeholders. I also turn to the issue of inclusion or exclusion of GST from turnover and revenue figures. And this is one that is problematic and disadvantages retailers who sell products and services which are predominantly covered by GST. Prior to the legislation, most centres assumed GST was not included and added a flat 10% to the turnover figures for all tenants. as there was not a trustful relationship between all parties. Under the legislation, the proposal is to include GST on all turnover figures, and this is problematic. For example, a greengrocer who sells no products that are subject to GST, for an example, might report $110,000 in retail sales in any period, but would report the same amount of that income as taxable income to the tax office, while a jewellery store who sells all products including GST would report $110,000 in retail sales, but in fact their taxable income is only $100,000. The Minister claims that this was an agreement of the working party, and I agree with that, but I also have spoken to some of the retail associations and other stakeholders, and they were unaware of the impacts. And those who were had just accepted it because of the length of time they had been in negotiation with the government and had considered that it was a one-off hit that was worth taking in order to get the changes. In my mind, if retailers are giving their sales data straight to the shopping centres electronically, then it appears to be quite a simple process to ensure that that data is actually correct and actually reflects the real value of those transactions to the centre. In fact, if I think about a retail travel agent, for example, their turnover figure might be $25,000 for a trip overseas, and yet they're actually spending nothing like that in terms of the impact and the turnover that they report as income, because their commissions are so small. And I can give you hundreds of examples like that. But anyway, at this point, let's move on. A major advantage of the legislation with benchmarking of rents in terms of the turnover will be the ability of them to compare rental figures across tenants in their centres. And specialist retail valuers work with the Office of the Small Business Commissioner. However, they don't report to the Commissioner. Small businesses can ask for a value of their retail business, and this isn't covered by the legislation or the Act. However, I suggested to the Minister that tenants should be informed of this service to enable them to better work on their businesses. They'll seek to promote the rollout of these specialist retail values to engage them with tenants as part of the campaign to inform the industry of their availability. And that's what the Minister's informed me they'll do, so I'm hoping that that does happen. I will turn now to the draft Retail Industry Code of Practice and the reporting of sales and occupancy costs. So the matter of this code is still outstanding business for the working party, and the Minister indicated this in his speech when he said, "I'm also pleased to update the House on an industry-first development. The major retail industry stakeholders have reached agreement without the heavy hand of government on a voluntary code of conduct, which we will call the code." He then goes on to talk about who he's consulted with, what it covers, and to say, talk about he's been pleased that there's a number of specialist lessee groups who are seeking to enter into the code. Now, the code that the Minister is referring to in his speech is the one dated April 2016, which is a compromise one, and in no way, according to some stakeholders, as comprehensive as the May 2014 code. It was submitted to the Minister's office at his request, the 2014 code that is, and nothing was done to progress the matter until it was known what was going to happen with the legislation. And the reason for the compromise was that some stakeholders could not reach agreement in respect of the 2014 code. There's a view amongst some stakeholders that some of the other stakeholders shouldn't have even been a party to the code, as they do not provide sales figures to landlords, which is a key component of it, because they're prevented from doing so by federal legislation relating to the industry. So, contrary to what the Minister's been saying, the code is not done and dusted. And if I go back to some of my concerns about disclosure of outgoing, there's some more to say about that in a minute. And when I asked the Minister for the most up-to-date version of the code, after he showed he was unclear actually whether or not online transactions were covered by the code or the legislation, he agreed it was still a bit confusing. And again, I asked why, after 3 years of debate on this and negotiation, is the Minister's and his office unclear on what's covered in the code and what's not. Now, the bill also has a concern around the disclosure of outgoings, and this is obviously extra cost addition to the rent. So the bill requires full disclosure in the lessor's disclosure statement of any obligation of the lessee to contribute to the lessor's outgoings and to prevent the recovery from a lessee of outgoings that are not disclosed. And that is very fair. I mean, you can't have a rental agreement which has a set amount and say, well, your rent, your water, your electricity, all these other outgoings are going to be about such, but we might just increase that for you because we haven't made good planning. And the legislation is definitely designed to stop outgoings increasing for the retailer due to the poor business planning by the landlord. So if they don't include reasonable increases of wages for security costs or increases in cost of utilities. And in the Minister's second reading speech, however, he refers specifically to a doubling in land tax as being unreasonable. And I'm going to quote from the Minister's speech here, as it's confusing on this point, and a fact of which his office appeared to be aware of when I raised it with him. He said, future increases in the outgoings will be limited by reference to the estimated amount, for example, the cost from the previous year. To illustrate what this means, imagine the landlord estimates that a tenant's contribution for land tax will be $1,000 per quarter, but the actual cost is $2,000. This represents a variation of 100%. Therefore, the tenant will be liable for only 50% of the actual amount of the outgoing throughout the lease. Given that this is subject to statutory determinations beyond the control of the landlord and at the whim of the government in some cases, this would appear to be one of the few examples of a reasonable grounds to increase outgoings, and it's a very dangerous ground, I think, for the Minister to be using that as an example where landlords would not be able to recoup them. Another example is the government's proposed new emergency services property levy, which is scheduled to commence on the 1st of July in 2017. However, it's not yet been legislated and applicable levy rates have not yet been released. So this exposes both the retailer and the landlord to more avenues of conflict over what is reasonable, with some unhelpful comments from the Minister in his second reading speech. It could be seen to be shifting a disproportionate amount of risk onto the landlord where they are price takers, for example, statutory charges such as rates, land tax, electricity and water. And the Shopping Centre Council indeed has requested this section be removed from in full or moved to a more relevant section of the Act, for example, under Part 3 of rent and outgoings, so that the new provisions could be read in the context of existing regulation regarding outgoings. And this also has an impact on small retailers who may be in an area or a zone where there's been significant improvement to the shopping centre precinct. So, for example, in my electorate, there's been a $400 million investment into a retail shopping centre. And we all know that as soon as that is completed, the Valuer General will come to that area and he will, or she, will slap on a new valuation, and that will have a significant impact of rates. Now, you would hope that the major retailer would have factored that into their cost of their renovations because they would have, in that sense, entered into a lease arrangement with their tenants, which may not be reviewable for 5 years. And yet the extra foot traffic that is generated by the successful renovation may increase the turnover very well for the tenant, but not so much for the landlord. And then if you think beyond just that shopping centre, but to the ancillary shopping centres, like the little people who have maybe 5 shops in a strip alongside it, their rates will also increase. And while they've done nothing to benefit from that, their retailers similarly have done nothing to benefit from that, but will get higher turnover where the landlord will get higher outgoings. And so the Minister's comments in this are quite dangerous. Fundamentally, the concerns and proposed amendments expressed by the Shopping Centre Council of Australia to me don't change the government's intent. Rather, they provide clarity and reduce risk on issues where all the weight of the regulation and risk will sit with landlords. Given that the Minister's second reading speech is what will be used by the courts to interpret the government's intentions where disputes occur, it's important that in his reply he clarifies this important point at the very least. And I do note that his staff were aware of it when I spoke to them about that issue earlier in this process. I also understand that the Western Australian and Victorian governments are waiting on the actions we take in New South Wales before amending their own legislation. So I urge the Minister for Small Business and those in other states to look carefully at how this legislation does act. I also want to talk about the removal of the minimum 5-year term, and that's where Section 16 is repealed and therefore removes the requirement for that 5-year minimum term for retail leases. And there has been some disagreement expressed to me on this issue. Some believe the minimum 5-year term should be maintained as it provides certainty and security to tenants. And it was a key reform introduced by the Act in 1994 due to concerns that some landlords may have been taking advantage of retail tenants, letting them for very relatively short terms and on expiration reletting them at a premium to a competitor of the tenant. Other stakeholders believe that a shorter term can be used through other means using a certificate. However, this adds cost as it requires a solicitor to draft it. But again, the Law Society is concerned that leasees have access to proper advice should they take a longer lease. And there is a lot of argument, of course, around a model lease. And this is something that government needs to keep an eye on how that's operating and what rights are being maintained for both parties. The classification of shopping centre spaces in office blocks has also brought another area of contention. It brings shops that are part of office spaces into the legislation, for example, the food court at the bottom of the MLC Tower that many in this place would be well familiar with, or shops at the bottom of Deutsche Bank across the road. The current wording to include the retail space in office towers, such as MLC, etc., could be interpreted as referring to non-retailers and non-retail floor space. And while the Minister's second reading speech confirms that this is not the intention of the bill nor of the government, and this was the understanding of all the parties, legal advice obtained by some stakeholders indicates that there are concerns with how that legislation could be interpreted in terms of drafting. Again, this is something I've raised with the Minister and his office, and it's up to him and the government to decide whether or not they accept that proposed alternative amendment to still include the retail components but not have the unintended consequence of capturing non-retail space. There are a number of other concerns which different stakeholders have raised with me, many. I mean, in a bill of more than 50 changes to legislation, of course there will be a variety of views, and I will not go into them, you'll be pleased to know, in this time, but I assure all the stakeholders that I will continue to monitor the operation of this legislation, and the opposition will be holding the government to account to ensure that unintended consequences are not to the detriment of those who are unable to address them. There is, however, one final aspect of the legislation which raises great concerns with me is something which should be addressed, and that's the retrospectivity. Now, if you do a word search through the bill, you won't see this should act retrospectively. But if you actually look at how it is operating, there are concerns. So it aims to provide additional protections for lessees and contains amendments to the current Act which reflect consensus against stakeholders. But there's this glaring fault in the drafting that must be addressed before it should become law. The bill proposes to insert a Part 7 to Schedule 3 of the Retail Leases Act 1994, and it reads in full, an amendment made by the 2016 Amending Act extends to a lease entered into and a disclosure statement given before the commencement of the amendment, except as otherwise provided by this schedule. The Law Society of New South Wales has expressed concern with the formulation of this section, as the retrospectivity may become unworkable and lead to unfair outcomes, particularly as there are exemptions which can lead to further uncertainty. More broadly, the Law Society, just as the opposition does, opposes retrospectivity on general principle, viewing the section as potentially compromising the rule of law, and suggests the provision should be given a much more limited scope than having a blanket retrospectivity with some exceptions. When I expressed these concerns to the Minister's office in November, they indicated that this could be a drafting error and that they may be open to an amendment on this. However, as late as yesterday I was advised that they were not sure if it was retrospective. Again, it concerns me about the lack of scrutiny on this and the attention to detail. Of course, there are some benefits of the Act which will clearly benefit retailers, including more clarity in relation to the sale of an existing business through reform of the assignment criteria, the provision of certainty with regard to how bank guarantees are treated by landlords, not only providing clear notice periods before calling in such a security, but importantly the timely return to the lessee at lease end or assignment. The introduction of the Code of Conduct sales reporting will provide more transparent market data around occupancy costs and improved research capabilities, which is very important given the leading role that retail spaces play in our economy. And the introduction of mandatory lease registration will supply the opportunity for lessees to perform effective investigations into commercial markets and support sound business decision making, all of which create the opportunity to improve the transparency of the market for retail leases in New South Wales. Now, I've spoken to very many stakeholders, and they are keen to proceed with the bill on the basis that it addresses generally the points of consensus. They do, however, anticipate there will be more challenges that arise in this space in the next 4 years, and therefore that the legislation will need to be amended and developed further in the future. And if it goes through, as it has been pushed through by the government, I agree wholeheartedly with them. All stakeholders have discussed the long time frame for the introduction of the bill and the extensive consultation period of the government, and it would be remiss of me to stand in the way of that on behalf of the opposition. All stakeholders have expressed the view that amendments should be made with the agreement of the government, and I agree on that as well. They have waited long enough, and the opposition respects the view of the many, many people who have engaged with me on this issue. I thank you again for your generous time in sharing your views, and I hope that the Minister will address these issues in his speech and reply, and I commend the bill to the House. Thank you.